Good evening and welcome to the meeting of the Board of Selectmen for April 22nd, 2014. I'll call to order the meeting right now. First item on the agenda is the approval of the meeting minutes for April 1st, 2014.
Move approval of the April 1st, 2014 minutes.
Second.
Motion made and seconded. All in favor?
Aye.
Aye.
It's unanimous. Number 3 on the agenda is the future meeting dates. We do have town meeting coming up the first
We'll
week
post
in.
everything.
So we're scheduled to meet on the 28th and May 1st. The 28th is at 4:30 in the afternoon, and that is to
Approve
the
comment letter
for the Henry's building.
Henry's 40B project.
Then May 1st will be our reorganization meeting
Yes.
after the election, and then we have May 5th, 6th, 8th, 12th, 13th, 15th, depending on how long town meeting goes.
Let's hope not.
Yeah, hopefully it's 2 nights.
What time would you like to be posted for before town meeting, 6 or 6:30?
What time does town meeting start?
7:30.
I would say unless there's anything pressing, 6:30.
6:30, yeah.
Always play it by ear if there's something that comes up.
And those meetings will be held at the high school,
Yes.
right before town meeting. Okay. All right, number 4 on the agenda is the approval of the payroll vendor warrants.
Move approval of the payroll and vendor warrants.
Second.
Motion made and seconded. All in favor?
Aye.
Aye.
It's unanimous. 5 is citizen speak. Anyone here for citizen speak? We have one person here for citizen speak. Mr. Irwin, how are you?
Well, thank you. Not so well, but thank you for having me anyways. I'm Gene Irwin, town meeting member, Precinct 9. And I'll thank you all in advance for your indulgence. I'm going to attempt to cover a huge, I think, important topic in just a few minutes, as briefly as I can for you. I'm here in regards to the poor farm. Thank you. I'm here in regards to the poor farm and Pulte's interest in purchasing it. And what I'm about to tell you today is very little known, and I believe that site is a national treasure, and it should not be disturbed. And now I'll try to tell you how and why. You have to go back, and also I did meet with the Milton Historical Commission about a week or so ago. I had met with several of them prior, informally, but I don't think they're fully up to speed, but I do believe I have their blessing to be here. As you look up there at the town of Milton seal, there's 3 individuals on it, and those individuals are Richard Collicott, Reverend Elliott, and Chief Chickatawbit. And back around 1600, before they all met, it was reported by the early, I want to call them settlers, but the white men who were patrolling the coast, looking for places to set up trade with the Indians and where the Americans could, or where the Europeans could take a foothold in New England. And in around 1620, Miles Standish and a whole bunch of pilgrims, as we all know, settled down in Plymouth. And just prior to that time, the Indians, the early settlers were fishing off our coast, and they were hoping to trade animal furs and all that sort of thing with the Indians. And another lucrative business was also kidnapping, and they'd kidnap the Indians in order to sell them for slaves. It was profitable. One such individual was Squanto, who was kidnapped, and he was brought back to Europe. And he learned English, and some wise people in England decided it was a good idea to send him back to the United States or to America. We could use him as an interpreter. So in 1620, he met with Miles Standish and the other pilgrims, and he introduced them to Chickatawbit, who was Milton's, or at that time Milton was called Unquity's, sachem. Now a sachem is the Indian word for chief. And down in Plymouth, Miles Standish and others met with Massasoit, who was the larger chief. He was chief of sort of all New England. And Miles Standish asked Squanto to visit the people in Milton at Richard Collicott's behest to establish a friendship and trade and business with the Indians. The Indians at that time, locally, along the coast of Massachusetts, were very much pro-European. And they liked the fact that the Pilgrims are here, and they wanted to trade with us because we had metals, knives, axes to cut down trees, that sort of thing that they didn't have. And in exchange, they taught us how to farm, how to hunt, but more importantly, we were an ally against the local Indians' enemies, who would have been the Narragansett Indians and the Pequot Indians. And so they made fast friends. Now, at around 1600, different historians estimate the Indian population here in the northeast coast of mostly New England, but primarily Massachusetts, Rhode Island, and up into New Hampshire, about 50,000 Indians. And here in Milton, they thought there were maybe as many as 10,000. And that was evidenced by all their fields that they had. And what many of us don't, I think, appreciate is President's Golf Course, I think, was a previous Indian field. I think the Governor Hutchison's field was previously an Indian cornfield. Indian Cliffs was another cornfield. And there was cornfields and farms mentioned off of Thatcher. And then if you go up to the Eustis Estate and the Carberries and the Bartolds, those were all Indian fields. So you can understand to maintain those huge amounts of fields, the population here was quite large. Now, if you go on further, in 1600, around 1617, there was a massive plague that hit this area, and the Indian population was devastated. It wiped out, some reports, they don't know exactly, but anywhere between 30 and 70% of the Indians. Most people think here in Milton was closer to 70%. Then later, in 1628, there was a second plague that took that vast population of Indians here, probably down to about, reports are, say, 20 to 60 individuals, down from tens of thousands or several thousand. Shortly thereafter, in 1636, October 8th to be exact, in the second plague, Chief Chickatawbut was taken by the plague. So his brother, a chief named Ketchimakin, stood in his place. Now the Indians at that time were pretty much almost all but wiped out. And Richard Collicott, who was an entrepreneur and a big fur trader, and he had set up shipbuilding down at Lower Mills, he went to Ketchimakin, his brother, and said, "How much will you sell the town of Milton for?" And at that time, the agreed upon price was 28 fathoms of wampuni, which is a denomination of wampum. And wampum were the Indian beads that were made out of quahog shells. And also, besides those 28 fathoms of wampuni, were 40 acres anywhere Ketchimakin thought best for the remaining tribe. So now we fast forward. Richard Collicott then, who became now the owner of Milton, he recorded that land with the London Company back in England. And the Massachusetts Bay Colony was set up, which was really a real estate corporation set up in Europe for investors to get wealthy in selling what were formerly Indian lands as real estate entrepreneurs. And one of those early investors was Israel Stoughton, Governor Stoughton's father. And at that time, as an early investor, he pretty much bought all of Milton Hill in 2 parcels. And it went from the grist mill that Israel Stoughton had prior to Baker Chocolates, all the way down to Christopher Drive, which was Gulliver's Creek, and that was another popular shipbuilding creek. Now, the remaining Indians, they wanted to settle on their 40 acres down in Lower Mills, but business was taken off for the white man between the grist mill and the fur trading and the hunting and agriculture and all that. So the Indians left Lower Mills, and they were now the new poor of Milton. The white man was doing fabulously well. The Indians, many of them orphaned, families all wiped out, and they were down to, say, 40 or 50 individuals. They were the new poor of Milton. So another parcel of land Israel Stoughton bought, besides pretty much all of Milton Hill, was 100 acres on Wigwam Hill. The history books describe Wigwam Hill. They first call this, where we are, Academy Hill, where the churches and the town hall are. And it's described as the land south and west, the first hill to the south and west of Academy Hill. And that puts you right at the poor farm. Now, those 100 acres that were recorded by Israel Stoughton with the London Company were also described as the Indian fields in the deed. Now, Israel Stoughton left that land, the 100 acres up there at Indian Cliffs, to his son William. And William Stoughton, besides being the governor of the witch trials and that sort of thing, he originally intended on being a minister. He went to Harvard University and was a theology major. And he then went from there to Oxford and Cambridge to study theology. But when he came back, the pressing issues of the locals and his vast real estate wealth, he really went into, say, real estate and government. Now, when William Stoughton died, and again I say he was a very pious man, out of those 100 acres up at Indian Cliffs, he extracted exactly 40 acres for the poor of Milton, for their use and benefit forever. Now, back then, he was a little bit like a Donald Trump. He could have told the Milton selectmen, who have ever since been in charge of the poor farm, that, hey, sell off the land, put the money in the bank, and take care of the poor forever. He could have easily done that, but he didn't. One of the things he did with his money is he set up a school over at Harvard University, which was ironically set up at that time, the same year Milton was purchased by Richard Collicott, because the early settlers were Christian and they felt awful for those Indians who had been decimated and pretty much run off their land. And I don't think there's any coincidence that when Richard Collicott bought Milton and the Indians could have 40 acres anywhere they thought best, and William Stoughton bequeathing them, or the poor of Milton, exactly 40 acres. Dennis, as you know, in real estate, 40 acres exactly is seldom ever seen. You know, oftentimes it's, 39 or 41 and 2/3 or something. And I don't think there's any coincidence. Now, a lot of people could say, and as Katie, you would fully appreciate, that this is circumstantial, some of what I'm saying. But circumstantial cases are also, our evidence is also some of the strongest we have. If Tom went to bed, this past winter, and a crime was committed and someone stated that it snowed out last night, well, you could have been in bed and you didn't see it snow. But when you woke up in the morning, there was snow on the ground. I say circumstantial cases are quite strong historically. And I believe that is the case. I believe William Stoughton bequeathed this land to the poor of Milton forever. Now, in addition to that, because of the plagues that wiped out the Indians back in 1617, it's reported in the different history texts that the Indians were dying at such a rapid rate they couldn't bury their dead properly, and a lot of the bodies were piling up. And I think it's only reasonable to presume that Wigwam Hill, that is elsewhere described by A.K. Teal in his History of the Town of Milton. He describes it as land running from the pound. There was a pound up there in 1877, down to Pine Tree Brook. So we're talking the slope of that land from Governor Stoughton Road down to the Yulin Rink as Wigwam Hill. So I firmly believe that is an Indian burial ground, whether we like it or not. And the laws regarding historical commission and conservation say that if you think there is reason to believe that there's more than 2 deceased Indians on that site, we're supposed to go to the State Historical Commission. And I believe they are in turn supposed to go to the Indian tribal councils here in Massachusetts. And if anyone is to ever touch that property, they should have the consent of the local Indians, who would probably be either the Wampanoags down in Mashpee or the Aquina in Martha's Vineyard. But in any sense, I believe, and I've walked that property several times, and I can tell you, there is evidence there of where the Indians had their campfires. And then when you talk about, okay, their wigwams and, how do they survive during the winters? Well, they needed moccasins and furs and the whole bit. There's evidence in the stones there where they cut and cleaned the animals. There are channels cut in the rocks. Their actual cutting tools, the granite stones, are still in place. And I say the place, I believe, is an archaeological treasure trove. But I think to develop this land, allow more test holes, and all that needs to be stopped in its tracks. And I believe that this land, in fact, has more history than Plymouth Plantation itself. And I think it should be treated as such. And I'm here to take any questions, but that's as best I can do to cover a big topic in a short amount of time. And I thank you for your patience.
Thanks, Gene, we appreciate it. Yep,
Thank you.
very informative.
I do have handouts, but I don't want to take all your time, but I can give them to you
Sure, yeah.
later.
Okay, thanks, Gene. Now returning to the Board of Selectmen meeting.
Anyone else for citizen speak? A couple of people came in after.
You want to come for citizen speak?
I think so, unless are you going to allow comments after you discuss interviews?
No. Yeah. Hello.
Thank you. I'm Ellen Denoyer. I'm here as a town meeting member of Precinct 2 and a member of the board of the Columbine Cliffs Neighborhood Association, and the Hendry's Building, 131 Elliott Street, is within our neighborhood boundaries. I'm also a trolley rider, and I'm here to express our neighborhood's concern and my personal concern about the severely deteriorated condition of the building. I would like to quote from the building inspector's report. The building is open to the weather, dilapidated, partially collapsed, and in danger of further collapse. Given its proximity to an active MBTA light rail commuter line and the public way along Elliott Street, there exists a significant risk of harm to passersby and the public in general. And there's more detail about internal collapse, the roof collapse, which could potentially cause further collapses and could cause the northerly wall along the MBTA rail line to collapse. So I think it's hard not to agree with the building inspector's report. And I believe that watching and waiting and hoping that the building won't collapse is not a prudent or effective strategy. I believe it's a public safety issue, and that the only prudent strategy is to demolish the building. So I appreciate that you are moving along on this issue, and I hope that you will take action to demolish the building.
Thanks, Ellen.
Thanks, Ellen.
Anyone else for citizen speak? No one else? Okay. We'll move on to item number 6 on the agenda, which is 131 Elliott Street hearing. I'd like to invite up Building Commissioner Joe Prondak, along with counsel for
Hello,
130.
Brian McDonough, I'm counsel for the Carrick Realty Trust. I'm joined by Fred Cowan, who is a structural engineer,
Okay.
who's familiar with the site. Grab that seat there.
You pull right up to the table. Mr. Prondak, you're going to give us a presentation?
I am.
On the condition of the building?
Yes.
And a history of what happened from the beginning.
History of what led up to the events of tonight.
Okay, off you go.
So as you know, back in March, I requested that the board take action under Mass General Law, Chapter 139, in seeking that the board would direct the owners of 131 Elliott Street to either remove or make safe the building.
Can I stop you just, do we have Brandon Moss coming here?
Um,
You know if he's coming in, Emery?
Yes, he is.
Supposed to
A
be.
return.
My understanding is she's on his way from Long Meadow.
Chapter 139, can you tell us what that is?
It is Brandon could speak to that better, but it is
Right.
a section within the Mass General Law, similar to Chapter 143, which we as building inspectors use in declaring buildings totally unsafe. Chapter 139, my understanding, is a little bit more broad in that it gives the selectman direct authority to direct action on a particular building that may be unsafe or otherwise a blight or nuisance to the neighborhood.
Okay.
So
Yeah, go ahead.
I'm going to go back to when...
We may stop you periodically
Oh,
just for
sure.
a question.
Yep. In February of 2012, the Conleys were renovating a building at 569 Adams Street. And whereas I drive by the building at 131 Elliott Street all the time, at one point during inspections on the building at Adams Street, I mentioned to Steve Conley that I had a concern for the structural integrity of the steel screen wall on the roof of the building at 131 Elliott Street. The screen wall was erected at some point to, well, it was dual purpose. It was to screen from view any mechanical equipment that was on the roof, and it was designed and acted as a sound barrier. But it was made entirely out of metal, had been subject to the elements for many, many years. Was, even from the ground, was noticeable that was substantially rusted. So I had mentioned to Steve in February that I wanted to get up and take a look and do an inspection on that screen wall. Sorry. He agreed that he would arrange for an inspection. However, it took several other phone calls and requests during other inspections when finally in April of 2012, we did arrange to get up on the roof. I met Steve Conley at the site on April 9th.
So you had a structure that was unsafe that you mentioned to Mr. Connolly in February,
Correct.
and it took until April to take action.
That's correct.
Did you send him a notice at that time?
We didn't, because the whole time he had been agreeing. He had told me, yes, I would get you up there, and the whole time we were trying to do this cooperatively.
Yep.
So I met Steve Conley at the building on April 9th. He had a mechanical lift there to get us up onto the roof, and he had an operator there for that lift. So we went up onto the roof of the building from the Elliott Street side. Steve Conley and I immediately noticed that the condition of the roof in general was bad, and we were concerned about walking in a direct straight path over towards the screen wall. So we were careful, both of us, to walk along the perimeter of the building where you could see the outlines of the wall below.
Joe, when you say bad, holes in the roof, or what made it look bad?
Holes in the roof, and just in other words, the roofing membrane was deteriorated to the point where you could see right through to the roof sheathing. And that, it's a tar and gravel roof, a lot of it, so that in order for it to deteriorate to that point, it's suffered some substantial weathering. So we carefully made our way over to the screen wall, and it was very obvious to me that the screen wall was substantially rotted and in danger of causing harm should there be a collapse or other event. Steve Conley disagreed with me at that point. He seemed to think there was not a big deal with the condition of the roof, and I was taken aback by that a little bit, because to me it was very obvious.
Well, he was trying to downplay it, obviously.
Yes.
Excuse me for a minute, could we just For the record, note that our attorney, town council, just arrived. Brandon Moss, just as Joe was starting his presentation. Just so everyone, has everyone met? Brandon, have you met?
I don't think so.
I think we should introduce everyone.
Nice to meet you.
How are you doing?
Fred Cowan, structural engineer.
Being on the roof and just looking around in general, looking over toward the east, toward the Central Ave side of the building, that was when I noticed that there was a substantial collapse to the roof of the building. I pointed that out to Steve. I said, this is something that needs to be addressed right away. He agreed. And we had some subsequent discussions and felt that it would be appropriate to have an engineer look at the situation. A report by Renee Mungier, professional engineer hired by the Conleys, dated 4/30/2012, indicated that steel and masonry portions of the building could be repaired and that certain wood portions of the building needed to be removed in short order. This report contained a disclaimer that it does not claim to be an itemization of all structural problems. In other words, I took it to be a cursory review of the building. The report did call out the immediate hazard of the screen wall that I had originally brought Steve up there to take a look at. Noted the roof collapse, substantial rot and mold in various portions of the building, cracking and spalling of masonry, deterioration of steel elements, and also expressed concern for safety of any persons who may perform work in that building. Steve Conley, again, took that report to say that the building was basically in good shape. We then told Steve that we needed to have the town have its own professional engineer perform an inspection. We engaged the services of EDG Group of Everett, Mass. And then reiterating again to Mr. Conley the urgency of this review by another structural engineer. Then Town Administrator Kevin Murn called Mr. Conley on the 18th of May in 2012 and explained to him that we wanted access to the building for our engineer on May 22nd. I heard back from Kevin Murn that Mr. Conley denied access to the building, which prompted me to write a letter to Mr. Conley saying that we would need to get a search warrant if he refused us access. The access eventually was granted, and on May 29th of 2012, structural engineer Clem McCary of the EDG Group did an inspection of the building. The town received his report on 6/14. Mr. McCary expressed concerns over both the town-owned portion of the building and the privately owned portion, or Conley's portion. He noted evidence of rot to the wooden elements of the town-owned portion, which could cause hazard to the public due to falling material or elements becoming dislodged during high winds. He further noted corrosion of steel on both portions, rotted wood, the collapsed roof, the likely instability of walls and significant wind events, and again, the dangerous sign structure or screen wall on the roof. Mr. McCary also opined that complete demolition of the building at that time would probably have been the most economical or feasible result for both parties. Over the next several weeks, I spent time reviewing the town's options with Kevin Murn, and having decided that it was most practical to tear down our portion of the building, we began the process of estimating a cost to tear down in preparation for requesting funds to the town meeting. We prepared a bid spec. Bids were received and opened on August 10th, 2012, but due to the high range of the four bids received, we had a range of $89,000 to $483,000. So the bid was, all on the advice of town council, all the bids were rejected, and we went back to the drawing board and refined the spec and began the process of bidding it again. I spoke to Steve Conley by phone on 7/23, 2012, at 2:30 PM. At that point, I was of the opinion that by this time, the Conleys should have, based on their own engineering report, that the Conleys should have come up with some sort of plan to either fix or remove the building. Fixing the building involves substantial work and substantial oversight by professional engineer. Steve indicated to me that he had no such plan in place. I then indicated to him that basically the time is up, and I would then write an order which essentially condemns the building. Steve asked if we could have another meeting to discuss it on the 24th, which was the day after, and I refused at that point. I felt we had given enough time for them to take some sort of substantial action. On 7/23, later that day, I did send a letter to the Conleys under Mass General Law, Chapter 143, stating that the building was in a dangerous state and needed to be either repaired or replaced in short order. Several pieces of correspondence were then traded by myself and Attorney McDonough.
So Joe, by this time now, we have 2 structural engineer reports, right?
We have our structural engineer report, and we have the first structural engineer hired by the Conleys, Mr. Rene Magna. 2
of 4, is that correct?
Yes, actually 2 of 5 now that I've gone back through the record.
Okay.
Mr. McDonough disputed many of my claims in my letters, and I completely disagreed with him. On the 27th of July in 2012, Steve Conley actually submitted an application to the building department to tear down the building. But subsequent to that, submitted no additional required information to further that application along.
You requested more information
Yes.
with the application?
Yes.
It never came?
It never came. In other words, there needs to be Conservation Commission approval, there needs to be approval from the MBTA, there needs to be a structural engineer's report laying out the procedure for demolition. None of that was submitted.
But Joe, let me ask you a question.
Sure.
If the roof partially collapsed tonight and it was in imminent danger of falling onto the street, would you need all those approvals?
I think if we had a situation like that, we would have to take some sort of action that would allow us to shut down the trolley lines, shut down the streets, sidewalks to both pedestrian and vehicular and MBTA traffic, and then given that,
It would be an emergency
it would be an
demolition.
emergency, and we'd just proceed as best we can to get the building to a point where it was safe.
Could this not be construed as an emergency demolition right now?
I believe it's been an emergency, given the proximity to the public way and the trolley line. I think there's clearly a difference here between a building that's in this shape, that is sitting 100 feet back from the road on 40 acres of land, but we have this building here, which is immediately adjacent to a trolley line, immediately adjacent to a well-traveled public way. I think there's a substantial difference.
And Joe, all the things that you mentioned before are things customarily required to issue a demolition permit?
Well, yes, on a building of this nature, yes, and the difference, the major difference on this particular building is its proximity to the T. So the T has a procedure, a licensing requirement on any work that happens next to their rail line, because of course they're concerned for their equipment, they're concerned for their passengers, so you have to follow their rules, so to speak.
I guess my point is, as long as we say that they have to follow all the criteria for getting a demolition permit, conservation and whatever else, there's going to be delay tactics for the next couple of years. There's no doubt about it. Why can't we issue an emergency demolition permit that they can start taking it down next week and bypass everything else?
I don't think we have the authority to bypass the T. We have to, I think would be out of line if we issued that permit without coordinating with the T. The line has to be shut down. The T serves thousands and thousands of commuters. They can't just stop the commuter line. So as we learned later in the process, which was included in the license that I obtained from the T for both properties, that there's costs associated with shutting down the line and running buses from Mattapan to Ashmont Station. And that has to be because you can't turn the trolley around at Central Avenue, so you have to bus the whole line.
Right, but I'm saying if one of the walls collapsed tonight, there'd be no problem in shutting down the line.
Well,
For however long it
depending
takes.
on where it collapsed, sure. I mean, if it
Right.
collapsed onto the catenary system or onto the line that actually runs the trolleys, the electric overhead line, yeah, certainly, it would have a devastating effect. And I tried to, I tried to bring up this urgency to the people I dealt with at the T. And it was a difficult agency to deal with at best. Numerous people involved. Again, I went through, as I detailed later in the report, I went through somewhat of a painstaking process to
It is painstaking. It seems to be
obtain that license.
catastrophe. A catastrophe must happen before this permit gets issued, in my opinion. In an emergency.
Agree, and I wish I could speed up the process. And we actually did go to the Conservation Commission and ask what they would require of this process and reiterated to them the emergency nature of it, but they still insisted that a notice of intent be filed. So again, I don't have the authority to override our Conservation Commission. I think they understand the nature of it, but they just didn't want to be left out of the picture entirely.
Continue.
Give me 1 second. On the 27th of July 2012, we also received an additional report from Fred Cowan, professional engineer, who was the gentleman sitting to my right. He was hired additionally by the Conleys. And the report recognized that the building has substantial deficiencies, including a partial collapse. The report does claim that the building is not subject to further collapse, yet contains statements which are contradictory to these findings. He talks about substantial rust and deterioration on steel joists and beams. He talks about areas where numerous and significant amounts of joists have to be replaced. So those statements, in order for a building to get to that point where you have significant damage due to rot and exposure to the elements, it makes no sense that to be able to make a blanket statement that the building is not subject to collapse. I don't see the logic there, so I disagreed with that second report.
Is this the third?
This would be the third report, the third engineer's report.
And did the previous one say it was subject to collapse? No. The previous reports, did any of the two reports before that say that the building was in danger of collapse?
Our engineer's report did say that.
It didn't, or it did?
It did say that.
Yeah.
And the report from the first engineer hired by Conley was much more detailed in saying that there was significant deterioration in the building, but stopped short of saying there was further danger of collapse.
Okay.
Over the next few weeks, with the help of town council, we wrote new bid specs for the demolition of our portion of the building. The bids were open on October 15, 2012. I also went through the process of obtaining a license from the MBTA, which included a whole list of conditions, including shutting down the line and paying for the busing. I obtained that, again, with an eye towards cooperation and a simultaneous tear down of the building. I obtained that license for both properties, our property at 0 Central Ave and the Conley property at 131 Elliott Street. The dates on that license ran from September 28, 2012 to 12/31/2012. and expired after that point. There was a successful bid awarded by the town. However, one dissatisfied bidder who was not awarded the bid appealed the bid to the Attorney General's office. The person making the appeal happened to be the same contractor that is Conley's contractor to demolish his own building. The Attorney General's office found that the basis for the appeal was not valid. However, they did find other deficiencies in the bid relative to hazardous materials. So the bid was rejected, and we were directed to rebid the process again. On 10/30/2012, due to a moderate wind event of the night before, several panels on the screen wall I noticed on my way to work were missing. In other words, they blew off of the sign. The screen wall that I originally brought to Mr. Conley's attention back in February, where he said there was, he claimed there was nothing wrong with it. Both of his engineers noted that there was significant issues with this wall. It wasn't until panels blew off of it that they got up there the next day and removed all of the panels from the sign. So, in other words, we notified him of a potential danger, and it wasn't, nothing was done to this structure until a potentially hazardous event occurred.
Did those panels land on the roof or on the ground?
I believe they landed on the roof. There was nothing visible on the ground. And then I had a conversation, again, Mr. Oppenheimer, Robert Oppenheimer, who is Mr. Conley's demolition contractor. He was the one that actually removed the panels. I had a conversation with him after those panels were removed, and he expressed concerns for the safety of his workers walking on the roof of that building, and indicated that the roof structure was so severely deteriorated it was not safe to walk on. On 12/3/2012, under the direction of independent counsel Len Keston, I sent a new condemnation order. On January 23rd, 2013, a portion of the cornice trim, approximately 7 feet long, weighing approximately 40 pounds.
Can I stop you for 1 second, John? So this is the second condemnation order, right?
Yes.
What happened to the first one? Did it just expire or what?
I'm not sure. Perhaps Attorney McDonough could fill us in better on that. But what I know did happen is back in July when Steve Conley put in the application for the demolition permit, they simultaneously filed an appeal in I'm assuming Superior Court, but there was no notice given to the town of that appeal.
Appealing that first condemnation order?
Yes.
What happened to that?
I believe it still languishes.
The appeal is still extant, yeah.
On January 23rd, 2013, a portion of the cornice trim of the building along Elliott Street, of the 131 Elliott Street portion of this building, fell off the roof and hit the sidewalk immediately adjacent to the building. Fortunately, there was no one walking by at the time. Nobody got hit by this, but certainly could have caused significant harm to anyone who would have got hit, brushed, or grazed by this piece of the building. I called Mr. Conley right away. He removed the debris from the sidewalk, but took no other action. Shortly after this, I asked Steve to chain off the parking lot in the back of that building to prevent people from parking immediately adjacent to that building. And he agreed. Again, he agreed verbally to do that. I asked him several other times along the road. To this day, the parking lot is still used by, I'm assuming, businesses in that neighborhood.
He agreed to chain it off, but he
agreed
didn't?
to chain it off, but he never did it.
So he agreed, and then he was told not to chain it off. Yeah.
Well, he agreed to do it, and he never did.
Joe, let me ask a question. How were you informed about that 7-foot piece falling off?
We received a phone call.
From someone in the area
Someone
who
in the
saw it
area,
happen?
Over the next several months to a year, the selectmen then engaged in negotiations with the Conleys, trying to effect, I believe, a simultaneous and cooperative tear down of the building. Again, that, from what I understand, proved fruitless. On a somewhat more minor nature, but still important, in November of 2013, I received phone calls from an immediate abutter to Conley's property, asking them if I could have them repair the stockade fence that abuts their property. And I called Steve. I asked him to do it. He said he would. He didn't do it. I called him a couple weeks later, asked him to do it. He said he would. To this day, the fence remains in disrepair.
Did their building cause the fence?
No, this is just, it's a wooden stockade fence. It's lived out its life. It's
Okay.
collapsed.
All right. But it's, the fence is owned by Carrick?
I would assume so.
Okay.
It's a continuation of a fence that wraps around the back of their property, so I believe. And then up on this Friday, April 18th, in coming to work, again, looking at the building, I noticed a significant portion of the facade of the building became dislodged, and a small piece of it has collapsed, and a larger piece of it is ready to collapse. I called Steve Conley on Friday, again, to let him know of the urgency of this, and he said he would have someone out to take a look at it on Monday. Again, to me, this is mind-boggling. If somebody were to call me up and tell me a piece of my building was hanging off, you couldn't get me there fast enough. And Mr. Conley said he would be there on Monday. There wasn't much more I could do. Tuesday, this morning, as I drove by the building, nothing has been done to that portion of the building.
It's still hanging off?
It's still hanging off the building. Nothing has been touched.
Can you explain a little bit more what that, or how big that piece is?
What location also?
I think I have some. I just have one shot, and that's this whole section of siding and facade right in this inside corner of the building. And I apologize for my photography, it probably doesn't do the.
Can you show me the part that's sticking out or falling up?
These are all the same photo.
I'm sorry, could you just point out the area? Just so I can-
This right here. So the potential here is for this whole section of siding and facade to collapse, and actually could pull more as it goes down.
So it's the siding.
It's siding and wood structure that holds that up. It's a facade of some sort.
Is that aluminum siding, or is it?
It's vinyl,
Vinyl.
and behind that is plywood and 2x4s, and
So it's the vinyl siding that's loose.
vinyl siding, wood framing, wood sheathing, that we can see. Again, for a building to decay to a point where the facade is falling off, there's got to be more stuff going on the inside and on the roof. It doesn't just happen in an isolated area. It's indicative of a larger problem.
So then we had a report done.
We had an additional report done by a gentleman named Mehul Dhruv of the same engineering firm, EDG Group. We wanted, this unfortunately is a little out of sequence, and I apologize for that. Went back to 5/23 of 2013. Mehul Dhruv, Clem McCary, the gentleman who did our first engineering report, retired. So Mehul is one of the principals of that firm that took over. And additionally, he concluded that The structural concerns of this building need to be addressed immediately. And that's no small undertaking. It either has to be repaired or demolished. On March 4th of 2014, Anne Marie Fagan and I had a meeting with Steve Conley here in this room to try again to negotiate a simultaneous and cooperative tear down of this building. Prior to this meeting, I told Steve about it. I said, we need to meet to try and discuss some cooperation here and what needs to happen to make these buildings come down together. And he asked me, what will the meeting be about? And I told him that we needed to discuss whose building comes down first, and we needed to discuss some of the buildings that cross property lines and how do we give permission to each other to go onto each other's property, along with the Conservation Commission issues, and do we do that jointly or separately? So he knew prior to the meeting what the meeting was going to be about. When we had the meeting, he was not prepared to answer or deal with any of the questions. He simply said to us that he would go back and discuss it with Jerry Conley and get back to us. At the end of that meeting, the meeting I believe was on a Tuesday, he was to get back to us at the end of the day, letting us know whether or not we could have permission to get in the building to. We need to get back in and have our hazardous materials specialist refine their findings. We wanted to know, and we wanted to know about tearing down his portion of the building that is immediately to the left of ours. And he said he would get back to us on that on Friday of that week. He did neither. So again, we were reaching out, we were trying to cooperate, trying to effect a simultaneous and cooperative tear down of this building, and we've received no positive feedback from the Conleys. In fact, at one point during the meeting, Mr. Conley mentioned that anything he does to this building has to somehow result in a profit to his business, as he is a businessman. And it seems to me that his concern for any threat to the safety of the general public is non-existent.
Now, at this point, I have to speak up. It's just turning into ad hominem attacks here on the person as opposed to speaking to the issues. And, you know, frankly, I have a problem with that. If you want to talk about the issue of whether or not the building is safe or needs to come down, please do so. But don't attack my client personally, particularly as to conversations that are completely from your own perspective. And, you know, please don't speak about what Mr. Conley was thinking or wasn't thinking or what his motives were. Let's just please keep it to the issues.
I am keeping to the issues. We've been for 2 years trying to get this building either repaired or removed, and we've gotten nowhere. We are no closer to having that done today than we were 2 years ago, despite the fact of the obvious need for something to happen to this building. No maintenance has been done to this building since the Conleys have owned it. It continues to get worse. What you view as an attack on your client, I am simply trying to put into perspective for the selectmen what I feel the town has been up against in trying to effectively administer the building code and get some significant action on this building.
Just speak to the facts.
I am speaking to the facts. Absolutely. That's all I've done.
Leave out the characterizations.
I've only spoken to the facts of our meetings and the facts of our correspondence.
So where are we today now, Joe? When was the last time you heard from the Conleys, either one?
My last conversation with Steve was on Friday, when I told him about the additional collapse of the facade of the building. That was the last I have heard from him.
So presently we have an application pending for a permit. Is that still open? Demolition permit?
That application, the first one expired would have expired 6 months.
So the second one was never put in after the conversations that we were jointly having to try and...
The second one was put in, but again, was never followed through on. Actually, I'm sorry, let me back up. It was not put in. I had a meeting with Rob Oppenheimer to discuss what needed to take place in order to get a demolition permit, but no application had been made.
You want to add anything, Attorney McDonough?
I would like to.
Sure, go ahead.
Just a couple of prefatory remarks. A sign screen on a roof, vinyl siding coming off of a side, a piece of trim. They're all important issues, but none of them speak to the issue of whether or not this is a structurally unsound building. Something sitting on a roof, a piece of siding coming off, a piece of trim falling off. These are things that happen to buildings, houses, structures of all kinds every day, and it doesn't mean that the structure is unsound and a danger of imminent collapse. So that's the first prefatory remark. Second prefatory remark is that there is a hole in the roof of this building, and that hole has allowed this building to be open to weather, and because it's been open to weather, there's been significant rot in the building. Now, this hole opened in a portion of the building that the town was obligated to remove from the inception of its purchase of its portion of the building. What is it now, 12, 13 years ago?
Where was that mentioned, Brian?
That was in the RFP from the MBTA. It was a deeded obligation that the purchaser of those portions of the building would be obligated to remove the structures upon the purchase. And so that's a deeded obligation. It's a deeded obligation that, in fact, has been recognized in town meeting previously by Attorney Flynn. And so the building has been open to weather, and it's been open to weather because of a collapse in a portion of the building that shouldn't have been there when the collapse occurred.
Can I add one thing?
Yeah.
I mean, I've been inside the building. I'm not sure if Dennis has been in. There's more than... The roof looks like Swiss cheese. I mean, you go inside the building, inside the portion that Carrick owns, and there are numerous holes. They're not gaping holes, but there are holes in the roof that you can see light through.
I'm sorry, I didn't mean to cut you off. By far the worst damage is to the roof that's situated on the portion that's not my client's property, but yet which has affected my client's property.
And it's since been determined it's neither of our property.
Well, and that's a bit of a bone of contention because, first of all, whether the town says it's its property or not, it had a deeded obligation to remove the structure up to my client's property line. Regardless of whether it owned it. And I believe that's why the MBTA required the removal up to my client's property line, because there is a little cloud on the title as to the strip that nobody will claim ownership of. But I'd also note that my client certainly doesn't own that piece of property. And as far as we can tell, nobody owns it, and if so, no private citizen owns it. I think the town is obligated to maintain the safety of that piece of property. If no private citizen owns it, it's the obligation of the town to maintain and protect that portion. I really don't want to make that just the focus of my comments.
Well, I just want to clear up one thing, that
Sure.
there is total disagreement on the purchase and sale agreement between the MBTA and the town in terms of the disclaimers, and everybody has said those are disclaimers, that they wouldn't guarantee that should, because one structure held up the other structure, basically are supporting, the one couldn't stand without the other, so that if there was to be further use of the building, then either an agreement would have to be made with the Conleys such that our building could remain standing, or it would have to be, we would have to build new supports for it. I don't think it said it had to be torn
Certainly
down.
there wasn't any agreement of the kind that you said that would need to happen if the structure was going to remain, right?
Right, but it was not a requirement in that purchase and sale to tear it down. I think that's incorrect.
Well, I disagree with that
Is-
reading.
And town council
Is that
agrees with us.
directly on the deed?
there is a disclaimer in the deed.
On the deed, yeah.
Saying that we don't guarantee that this building can stay standing without moving the supports that hold it up, because they're on Carrick Realty's property.
Okay, so again, this is down to interpretation. You
Legal
interpret,
interpretation, yes. Legal interpretation as opposed to personal opinion.
correct. So I mean, our attorney would interpret it that we don't have to take it down, but you're interpreting it that you do have to take it down.
And regardless of the fact, we want to take it down.
Well,
Correct.
and now, right, and that's why I don't want this to devolve too long into an argument over who owns the hole in the roof. Because, you know, you want to take your piece down, we want to take our piece down. That's the reality of the situation. Now, did we always want to take our piece down? No, we thought about it at one point, we changed our mind at another point, because quite frankly, you know, the direction of my client's piece of the property, development-wise, has changed over time. They originally wanted to do a mixed-use development there. It didn't work out. When that didn't work out, they wanted to have the array of their options available to them. And one of the options that they were seriously looking at is whether or not that building could be rehabbed in any way. And so, yes, they were resistant to the notion of tearing the building down in 2012, even though there was some thought at that point about possibly doing so. As everybody knows, my clients are now pursuing a project, and they're very excited about that project, and that project does call for the demolition of their building and the removal of their building, and they're more than happy to do it. You know, it's a little strange that they're being taken so much to task for this existing building, which has been branded a safety hazard, when the town does own part of the building, and the town has done nothing to remove its piece of this unsafe building.
I disagree.
Is it still standing?
We can't take it down. The buildings have to come down together. They're adjoined together. Part of Carrick Realty's building comes across, that front facade comes across our building. There's no way that we can take it down without damaging part of that property.
Well,
We're not willing to take that legal risk. We raised the funds 2 years ago to do this. We put it out to RFP twice.
Yeah.
Where is nothing in that statement? Twice we put it out to RFP. Raise the money, let the money go back because we had the end of the fiscal year hit and we couldn't demolish it.
Well, that's because a deal couldn't be agreed upon. There are a lot of contingencies.
No.
The town can, you can't tell me that the town is unable to take down the pieces of property that it owns if it deems them to be a safety hazard.
When they're joined together?
It's still a piece of property you own that you have deemed to be unsafe. If it's unsafe, you need to take it down, right?
The bigger concern is the bigger building that's unsafe as well.
Well,
So if they'll both come down together, we're more than willing to take ours.
that's precisely the point I'm making. You're being selective in
No.
your assertions as to what is the safe portion and the unsafe portion. But again,
No, we want the whole thing
this
down. Quite
Okay.
clearly, we want the entire thing down.
and that's good. The thing that you just said that is the most positive and useful in terms of getting to where you want to get and where my client now wants to get is that you want to do it simultaneously. And
Always said that.
I don't know whether you've always said that or not. I just know that right now that is the most important aspect to my clients, and it's really the only fly in the ointment vis-a-vis are getting a plan to remove this building. My client's concern really is that from a safety perspective, it sounds like we were hearing from our engineer that the safest way to get the structure down is to get the town's peripheral pieces removed first, to be followed by the bulk of the main structure, which belongs to my client. And so, if you're okay with going in that order, if that's not going to be an issue, then that's one less bridge we have to cross. But we're not averse to taking our building down. And we've got a demolition contractor ready to go. as soon as the town can get a demolition contractor of their own ready to go, those contractors should get together along with either side's or both sides' engineers, and let's get a plan and let's take it down. You know, whatever was in the past, I must confess, I don't know the intimate details as well as some other people here, but it really doesn't amount to much because the building's still there and it needs to come down. You want it down and we want it down, so let's
Brian,
do what we need to do.
Is your client willing to take down his building simultaneously with our building?
I think he is, yes. Yeah.
He is, however, insisting that ours come down first.
Well, we can't take ours down first. I mean,
The only concern, what was that look about? The only concern is that I don't want to be in a situation where, well, I'll tell you, there's two concerns that my client has. One is that it be taken down safely, and two, they want to avoid a situation where they're exposed to any liability in the form of a claim that,
it damaged our
geez,
building.
Conleys, when you were taking down your building, you damaged our property, and now they're looking down the barrel of some kind of a damages claim. So there's got to be a way to
We can
to give
certainly
each
give them a hold
side.
harmless clause, that's no,
Pardon me?
we can certainly give them a hold harmless clause.
And that's probably the most direct route, and I think they would not have a problem with that. So that's good. The other part of today that I just feel like I should comment on is there's been 2 condemnation orders. I appealed the first one. I filed an amended appeal to the second one. Truly, I would ask that another order not issue. And another order is not going to give the town any rights or remedies that it doesn't already possess vis-a-vis the orders that have already issued. All it's going to do is require my clients to incur more costs in the form of appealing yet another duplicative order, and the town incurring the costs of having to respond to that appeal. You've got what you need vis-a-vis rights and remedies in the existing order. So, you know, if we can't get to where I think we can get, you're armed with what you need. You don't need another order to issue. It's just going to ratchet up the legal costs for everybody, town and my clients. And so I'd ask you to consider not issuing another order because it's overkill at this point. The orders have been issued. You know, have at it by those orders. You don't need another third order out there.
So what's the difference between condemnation and Chapter 139?
Chapter 139 and Chapter 143 are both types of condemnation. It's just they have 2 different procedures. And, you know, what brings us here today is the Chapter 139 procedure would allow the building inspector to act. Previously, it was a Chapter 143 procedure. They both get you to the same end result, which is either the building being fixed or secured, the building being demolished, but they get you to the same end result.
So the first 2 condemnations were Chapter 143, is it?
They were.
There's a motion in front of us for Chapter 139 tonight,
Yes.
correct?
Yes. The Board of Selectmen is empowered under Chapter 139 to act. Chapter 143 is more of a power for the building inspector, building commissioner to
Can you tell
utilize.
how Chapter 139 would affect the process? So we go in front of a judge, what happens?
Well, the Chapter 139 process, so it would be up to the board tonight to decide if the board was inclined to issue an order, and then there's still the same right of appeal. In fact, Chapter 143, the right to appeal under Chapter 143 actually is the same means of appeal under Chapter 139.
Okay.
My understanding is that 143 deals specifically with condemnations for unsafe structures, whereas 139 deals with nuisances. And so not every structurally unsound building is a nuisance, and so 139 is broader in scope, where they're both addressing a purportedly structurally unsound building. They're essentially identical in effect and scope, and procedure.
Well, the one thing I would add is that 139 does have language about dilapidated and also dangerous structures.
Sure. No, I'm not saying it
Yep.
wouldn't apply. I just think I think 143 is more pinpointed to our circumstances of this situation, and 139 would apply as well, but also apply to a whole array of other public nuisances.
Could I ask a question? Perhaps it's Mr. Cowan, is it? In terms of the removal of both buildings, if they were to come down, whether you call it simultaneous or one right after the other, it's been said that our building has to come down first. Yet it would seem if our building came down first, we would have to stage from the street in order to take it down, causing closure of that street for a much more significant length of time than if the building were to come down from the Elliott Street side out, in other words, because then we would be able to stage as you went along and stay off the street, at least with our construction equipment or demolition equipment. And I'd just like to know what you think about that.
I'd like to point out that there has been a collapse in the adjacent building, which has caused to push in the wall of the 131 property.
Yes.
In order to take that demolition material away and protect the 131, has to be done from the side that
But
you're
we're not
on.
talking about protecting it, we're talking about taking them
We're
down.
talking about the procedure.
Yeah,
for
but I'm trying to
removal.
understand that.
So you have to take the safety aspect out of it. So it has to be done in a way that the 131 people stabilize the wall in question, and the other people, whoever they may be, take the collapse apart and remove the spoils of collapse. And none of those spoils of collapse are on the 131 property. So somebody's got to take responsibility for both sides to do this.
If you would have,
In other words, we have to have a coordinated effort.
well, I agree with
There's a
that.
property line between a collapse site and a building that I don't call unsafe. The collapse has caused a damage to the 131 building. A collapse of a couple of floors of that building and a
But
roof.
that's not the question I'm asking.
You're
That-
getting more to the logistics.
The
of how do we-
logistics of...
How do we take it
Well,
down
we've come to the conclusion, or hopefully we've come to the conclusion,
in the safest possible way?
everybody wants to take the entire structure down and do it somewhat simultaneously.
I obviously can't speak to
I understand.
what is the safest way to take
Yeah,
it down.
that's
Can
why
I
I'm
just
asking Mr. Cowan.
explain what, as a person in the construction business
Sure.
does? There has to be a collaboration between two entities in order to make this thing safe.
Yes.
That's where the construction experts and the demolition experts come in. And I don't think we could solve that problem at this table.
Okay, now you tell me what I want to hear. So the requirement to take ours down first is not necessarily true, we just don't know right now.
I think
Is
that's,
that a
I
fair
think
statement?
I think that's right. Well, let's assume for the sake of argument it's correct.
Okay.
And so is that going to be an ultimate impediment to our getting this building down, is where you're going with this, right? If somebody were to say, well, geez, you know, the assumption that the town's building needs to come down first because that's the safest way, it turns out that's not the safest way. You know, Carrick Realty Trust, you know, really might be that some portion of yours should come down first, followed by some portion of ours. Who knows?
Right. Mhm.
And so,
As long as that dialogue, as long as Carrick Realty is willing to have that dialogue and not
I believe,
mandate.
No, they are. I believe they are. And the mandates, you got to understand the point of view from which it was coming from, and it is the point of view of avoiding liability exposure. And so the earlier point that you made about working out hold harmless agreements that allow us to reach the comfort level that we need, that nobody's going to be
Suing somebody.
suing somebody about, you know, damage to pieces of respectively owned buildings that we both say we want to take down anyway.
Right.
Right? And so you know, long-winded way of repeating that I think we can get there. And I think we can work out something, you know, where there may have been hesitancy in the past to take down my client's building. You know, they're pursuing a project, and they're excited about the project, and this building's got to go, and so, they're not going to miss it, but they don't want to get themselves into trouble in the course of taking their building down. And so that's the part that just needs to be worked out, but really, it sounds like we're on the same page.
And I think every time I think we are, something seems to happen, and that's what worries us. That every time we get close, something happens. And we thought we were close a couple of months ago. I talked to Steve Conley personally,
Yeah,
and,
but
and he agreed the building has to come down. We're ready to take it down, and then
Yeah.
it blows up again.
I
We
mean,
don't want that to happen again.
And I understand what you're saying, but, the only thing I can add to that is there are any number of contingencies that we're going to run up against.
Sure.
Okay, that are going to need to get ironed out, and if you can't find agreement on some one of them,
If we could let the professional engineers and demolition contractors work out the logistics and do it post-haste, then
that's probably the best way to go, right? I mean, because what we're really talking about, eliminate the contingencies. Let's just talk about how do we take the building down, and how do we do it safely?
it's the safest and most efficient way to do it.
And what do we need to have in place so that nobody's going to be pointing the finger at the other and say, I've been harmed by the way that you took down your piece.
Brandon, can we have, do we have to do the 30B for our portion of the building?
You would, unless there was an emergency, that would be the only way to around the 30B process. And that's a question of fact. Is there an emergency on the town side?
How long does that take?
We can do the 30B process fairly quickly. I mean, fairly quickly, less than a month, I would think.
Yeah, I mean, in some respects, the work, the bid specs are already out there. I mean, there was a prior 30B process to demolish a building, so in some sense, the work's done to put together that procurement.
Mm-hmm.
We've already had somebody help us along with new specs anyways. Is that true, Joe?
We've had some preliminary help from a consultant from construction, from Suffolk Construction.
Make sure we've formally dealt with all the issues. So we've done an awful lot in terms of the preliminary groundwork to get that RFP out on the street.
Yeah.
You can have a fairly short window on the RFP. The 30B just deals with the bidding side of it.
I mean, so it doesn't drag on
Mhm.
in a way that's uncomfortable to the town. I think probably the next best step would be let's get some agreed upon deadlines. We'll each have our teams established by X date. We'll get together by Y date. Well, just so that the town can then say, look, everybody then knows, these are the steps, they need to happen by these points, or you're not left wondering, are we on track or are we not on track?
But Brian, that's the problem. You see, we've had deadlines after deadlines after deadlines.
Well, I can't speak to what's, I'm sorry, I didn't mean to cut you off. I can't speak to what's happened.
Right.
I can only
No,
lay out.
I'm telling you.
Which is fine.
Yeah.
And all I can say is, there's still a building there and it still needs to come down.
Correct.
And so let's try to get a process together that achieves that. So I'm throwing out the best suggestions I have.
Joe, go ahead.
With all due respect, trying to hammer out an agreement is exactly what we tried to do, Anne Marie Fagan and myself, with Steve Conley on March 4th. It got us nowhere. Mr. McDonough has said, repeatedly said, I think we can come to an agreement, but he's given us no guarantees. I respectfully request that the board move forward with the order under 139. If we can stop that process at any point, if the Conleys sit down to the table with us and come to some definitive agreement. The consultant that I have spoken to, who has been in the demolition business for many, many years, stated with no uncertain terms, the best way to tear this building down is for the Conleys to come down first and work forward towards Elliott Street. I've been a building inspector for 28 years. 18 years in the city of Quincy, I've overseen the demolition of many, many, many commercial buildings, including the Mag Scale building, if anyone remembers that, on the old Stop and Shop site at North Quincy. I know a little bit about how to tear a building down, and it's no mystery that this building needs to come down from the west end toward the east. That means the Conley's portion first. But before anything can happen, before we can even properly put it out to bid, we need some agreement from them. We have already told Conley's in no uncertain terms that we will take responsibility for the unowned portion. We will tear that down. We've said that to them. There's a portion of this building to the left of our building that it's a sliver of a building. It's owned by the Conleys. We need an agreement from them as to what is going to happen. Do we tear that down? Do we charge them per square foot of tearing that down? Do we do it for them to speed up the process at no charge? We've asked for an agreement on that, and we haven't got it. We've asked repeatedly to come to an agreement, and we've gotten nowhere. That's why we're here tonight.
Well, I mean, so let's talk about what are the alternatives. So you haven't got to agreement so far, so now you just throw up your hands and say, all right, we're never going to get to an agreement. All right, well then where does that leave you? It leaves you to your remedies. You already have whatever remedies they are based upon the prior condemnation orders. Issuance of a new order tonight does nothing except for probably, create more bad feeling and make it harder for us to get together to hammer out an agreement that everybody can live with and get the thing done. So, great, you've got a new order out there that gives you no new rights, all the same rights you already possess, and it's just created more ill will. I respectfully think that it's, again, repetitive, duplicative, and really probably not going to be helpful to what we're trying to create here, which is, a path to the end line. And, past frustrations aside, we got to keep working at this, I think, and if you're just going to say, well, we're not going to work at it anymore, then it's going to be a less than optimal result for everybody, for the town, for my clients, and so we should keep talking, and we should, I think, try to create an environment where the rhetoric's toned down on both sides, and opportunities for creating goodwill rather than perpetuating ill will ought to be the order of the day.
Brandon, is that correct, that we don't have any new rights after a motion is made tonight?
I think what Attorney McDonough is probably getting at is the two prior condemnation orders. This 139 order that would issue tonight, I mean, that is an order to do something, whatever that order says. So that is rights. So that's not. I would have to disagree on that because I think those orders are in the past, and this is really a fresh process. This is a process through the Board of Selectmen.
Well, that's one of the questions. So, Brandon, were the prior orders issued by the board or by the building inspector?
They were issued by the building inspector.
Both of them.
Yes.
So it is emanating from a different body, but it's still a condemnation order, and now you're issuing another condemnation order, and that order will be subject to the same appellate process, appeal to the Superior Court. And
what about stipulating to one, though?
Stipulating to
a 139 order so that the board issues it and your client, because I think one thing about deadlines is that could be contained in a 139 order.
Well, as far as deadlines,
and commitments,
that's a possibility. We're certainly not going to stipulate to a finding that our building's a nuisance.
Well, I think, that process, like I said, is dangerous and dilapidated buildings in addition to nuisance structures. So
we're not going to stipulate to anything about our building being unsafe, because we frankly believe our building is not unsafe, and we've got a structural engineer who's given us that opinion. Nevertheless, we're willing to take our building now because it fits our development plan going forward. So we want to take our building down. We want to take it down not because we think it's a risk of imminent collapse, but because it fits with our plans and it satisfies the town's desire to have the building down. But we're not going to give a stipulation that says anything like our building is unsafe. So stipulation might not be the route to go, and I think it gets us off track to where we do want to go.
Brandon, can I ask a question?
Yes.
If we were, if we were to, and I'm just speaking for myself because we certainly haven't come to any meeting of the minds, you know, clearly, I think we all have this concern that every time we try and negotiate, it falls apart and it just gets pushed further and further down the road, and none of us want to see that. Is there a mechanism by which we could continue this hearing?
Yes.
Such that to a date next week, and in the interim, look to see some significant, and I mean significant, I mean to see Jerry Conley and Steve Conley in here tomorrow with trying to make some progress towards this thing, that maybe we won't go forward with it, but otherwise, the hearing will continue next week.
Yeah, I think although in terms of that you're not agreeable to stipulate to an order, I would assume you'd be agreeable to stipulate to have, with your assent, to have the hearing continued, correct?
Oh, I have no problem with continuing the hearing to allow the parties to talk between now and the continued hearing. I mean, that makes good sense.
That was my suggestion.
I'm personally, I'm not in favor of that because we've seen it too many times over the last 2 years.
But, I'm sorry, I didn't.
Go ahead.
But, all right, where do you go from a further condemnation order? Where do you go? Okay, we're going to take down the whole building, we meaning the town, and so now you've got to front the cost of taking down the whole building? I mean, that's not a palatable result for anybody. So, you know, you get another order out there that gives you the same rights that you already possess pursuant to the prior orders, and then where do you go?
Joe, let me ask you, so with the 4 or 5 structural engineering reports, 2 are saying that the building is not in imminent danger of collapse, and 2 are saying that it is. Is that correct?
Essentially, yes. But I disagree with, I would ask, Mr. Cowan is essentially Mr. Cowan's reports. He has 2 reports in there, which makes up 2 of the 5. There's a portion of the building to the west end, which is purely owned by the Conleys. It has nothing to do, it is nowhere near attached to our building or the unowned portion of the building. If you look up at the roof, it's a steel structure. There are holes in it, substantial holes in a steel roof structure. Yet in his report,
In whose report?
in this gentleman's report, it says the roof deck is rotted, but the joists are okay. How can you possibly come to that conclusion?
As a structural engineer, I can.
Okay.
I'm licensed to do this, and so is Mayhul, who you hired.
And he says,
He didn't say that this was an imminent collapse situation. The word collapse was never used in any of those reports.
Mr. Cowan, when was the last time you were in the building to inspect it?
May of 13.
May of 2013.
Yeah. Now, I'd like to explain something about my report. And I go back to the previous report, the first report that was written. First of all, Mr. Mounier, who did the report, was asked by the developer to determine whether the building was reusable. All right? Was it feasible to reuse it? He didn't come to the conclusion that it was going to be an imminent danger of collapse. He would have been in danger of losing his license. And so would I. Had I written a report about that building and neglected to say that there was a danger for... That's a very, very important thing to understand. We have a disagreement with this building inspector. Simple as that.
Well, is it accurate to say your disagreement is with the other engineer, or just with Joe?
I don't have a disagreement with Mr. Mounier. As a matter of fact, I don't have a disagreement with Ms. Mehul Drews or Clem McCann.
I think the point he was making there is that Mounier's, is that how you say his name?
Mounier.
Mounier's report doesn't anywhere say that the building is a danger to the public. And that's not the kind of thing that you'd leave out of an engineering report if it was in fact a danger of imminent collapse. And so I think that's essentially what you're saying there, right?
Could I just read one, and this is out of, not yours, Mr. Cowan, it's out of the EDG report of June 14, 2012, where it says the roof structure contains certain areas exhibit localized failure and instability. A large sign supported roof is in danger of condition. That's the roof. But the roof structure he's talking about. I guess, has anybody actually inspected those beams that where those holes are? And I'm not talking about where the collapse is,
Yes.
but you've physically been up there.
The framing of the roof is okay. There's holes in the roof because the roof deck rusted and
rotted away.
But I want to emphasize, I'm very serious about the work I do. I've been in business for 40 years.
I understand.
And I wouldn't condemn a building without asking an engineer.
Yeah, I think it's important to understand too that in those earlier reports, nobody's saying that this building's not in tough shape. If you ever wanted to use it again, it would take significant work to bring it back. But that's substantially different than saying that it's an imminent threat of collapse. Yeah, if you wanted to ever make that building occupiable, you'd have to sink a lot of money into it, and nobody's debating that. I mean, that's an agreed premise, but it does not mean that the building's in imminent risk of collapse. And our structural engineer has said that, and earlier structural engineers didn't say that it was an imminent threat of collapse, and if it were, that's a point they would have made.
Well, they did in fact, well, and again, I'm reading from that same report. In conclusion, the building must be either completely demolished or repaired within a brief span time. Due to the extent of work required to repair the structure, is likely demolition be the most practical
Tom?
approach. This is the June 2012.
Who did that report?
The EDG report. So clearly, this one does call, make some alarming statements. If you say, does it use the word in imminent danger of collapsing? No, it doesn't. But it certainly.
Could I add to that
Sure.
statement a bit? You have to understand that there is a collapse involved here.
Sure.
And we have been talking about a building in terms of two different subjects. We've been taking a great deal of time talking about the condition of the 131 building. But what I focus on when I use the word collapse is the fact that there was a collapse in the building next door
It's putting pressure
that
on others.
caused a problem in the 131 building that could result in a collapse. That's where we should be focusing on.
And I think we're saying the same thing.
and
The
rest of
entire
it-
structure is unsafe
And the
because
rest of it,
collapse.
the rest of it doesn't really make a lot of sense to focus on, because the reason we're here is because of the fact that there's an adjacent building that has collapsed and is causing damage to our building.
Okay, so
And it's all the more reason why our efforts really need to be focused on getting the whole structure down, because with the structure completely down, any claim of damage to our building by a hole in somebody else's building becomes a moot point.
That's
right?
correct.
So that'd be a nice problem to solve for everybody. And to boot, everybody wants the building down for their own personal aspirations and plans going forward. So there's a lot to be won by everybody if we can get to a point where we've got a plan in place to take this building down. And my clients have instructed me that they want to take their building down. Yet past efforts have been unsuccessful, but, let's go back to the drawing board. It's worth the effort.
I have a two-part question, and Brandon, this is for you. In the event that we pass this motion tonight, and they appeal it, which they probably will, how long will that delay any demolition, approximately?
Well, if the motion passes tonight, the effective issue is the written order under Chapter 139. So even if the board votes tonight, the board still has to adopt that written order, and that's the point of appeal. It's really a function of the courts, the judicial system, whether the town were to go in and request a preliminary injunction or to have that building ordered demolished or something to be done to secure that.
How soon could that happen?
Well, it can be done within probably a couple of weeks. It really depends, I think, on the court's schedule to accommodate a hearing on a motion for an injunction. So
This is even though they've appealed it.
For what it's worth, my understanding of the law is that if we appeal it, that does not prohibit the town from going ahead and doing whatever it will do. What it does is create liability exposure if the town were proven to have condemned a building that was not structurally unsound. And so it creates a bit of a dice roll, but it doesn't stop the town from doing whatever it wants to do anyway. And the town has that ability right now pursuant to the existing two prior orders.
My understanding
In
of
the
what
same
would happen
position.
is you would have a lien on if we were to tear it down under our dime, we would have a lien on the property for.
Right.
But that's my question. How soon could we have a demolition permit to take everything down? If we go to 139 and they appeal it?
yeah, I mean, for the town to demolish it, I mean, usually it's about a three-day process to give the current building owner the time to do it themselves. The town doing it's a last resort.
Are we talking 6 months?
We're not talking 6 months because, I mean.
Conservation, everything?
Yeah, I think if the town were given the go-ahead in some fashion to tear the building down on its own, we would again have to secure a license from the T, secure approval from the Conservation Commission, and put it out to bid.
Okay.
Certainly, the town acting on the whole building at once clarifies a lot of the issues that we're trying to get clarified and would be able to more.
Would we be safe in saying 6 months, Joe?
I think 6 months is a reasonable estimate.
Reasonable time. Bill Clark, I know Bill is back in the back. 57 units the Connollys have applied for in their development. Okay? Assuming that no objections and it sails right through, how soon do you think they can get a permit to build their 40B?
If everything sails through,
Yes. Are we talking 6 months?
yep.
So if it's going to be 6 months of legalities versus 6 months of allowing them to get a permit and take it down, I'm not sure which way we should go. Does that make sense?
I think you asked two different questions. You asked the 40B question.
Well, no, I'm saying if they do their 40B and they get a permit in 6 months to actually go ahead and build their 57
And you're
units,
saying that's when they're going to take it down, in your estimation? Or-
and if we go this legal route, and it's still going to take 6 months to take it down
And be costly.
and be very costly. Am I making myself clear?
Sure.
No, I think they're two separate things, really.
It is two separate things, but I'm saying if the 40B goes through pretty smoothly, and they get a permit in 6 months to build, and we go through with this process, and by the time we have conservation and whatever else over us, it's still going to be 6 months, and they meet together when the Connollys are going to be taking the building down anyway, after they get...
Would it take 6 months to get through the demolition permit process?
I think it could take as long as 6 months if we're including, I think if we came to an agreement as to how this all were to come down, if we came to that agreement tomorrow, and there was no more dispute over that, we still have to put ours out to public bid, whereas the Conleys can just move forward with their own demolition contractor.
Sure, and that's, right, we can be quicker. And you have
So if we could come to an agreement, we could probably do it in as soon as 3 months. But if it's a situation where the town is seeking presumably permission from the court to go in and take over the property and tear the building down. I think if you couple that into the mix, then we're talking 6 months. I'm just guesstimating.
Right, but assuming we come to a meeting of the minds, then we could probably do it sooner, I guess is a...
Of course, the quickest of all would be some kind of a resolution that involves a transfer of the town's property to my client, because we can then act, well, I throw it out there. I mean, you might as well have everything on the table, right? What's the quickest way to get to the end game? If it's not something that works for the town wouldn't do it. But why not revisit? I wouldn't take any potential option off the table. If the goal here is, in part, speed.
I would just add to that by going forward with the process tonight, no options are taken off the table. If the Conleys decide they want to cooperate and do this cooperatively, they're free to do that, and we would simply dismiss this process and drop it.
Okay.
And all I would say is that it will also afford you no additional options, but it will have a cost attached to it in terms of further legal fees.
So that would be the only thing extra, would be the cost to the town. And I think it may be worth it to do them simultaneously. Do the 40B application and do the 139, and if the 40B comes through before the 139 goes through, well, then we can squash it.
And so are we talking in the interim or not? Or are you saying it's just a race to those two outcomes?
We can make a decision afterwards if the 139 ruling comes through before the permit comes through. If you're pretty close, we can hold off. Something like that.
I would respectfully, I still think that the best option is a continuance to allow us to talk, at least a short continuance. Because, if we can come to some sort of a negotiated agreement in a relatively short time frame, that's going to be the best outcome for everybody.
Brian, I think you're doing a great job for your clients, I really do, but the history is we can't seem to come to an agreement with.
I know, but that's
the problem.
not a good reason not to keep trying.
I think how many times do we have to try, It's a simple project.
I don't want to mix the two concepts, so I think we should just focus on what we're here for, what's on our agenda right now, which is the 139 hearing. And we've all been very concerned about the state of this building. I think everyone believes that it's a public safety concern of the highest degree. Now, we might have a difference of opinion between engineers as to what the terminology might be or what the state of it is, but it's a building that's in a very it's in terrible condition. It's a concern, especially during the winter. It was a real concern that some of the storms that we had, that there could be, anything could happen. There could be more damage. There could be a further collapse. So what I hear from our building commissioner is that he's very concerned about public safety. As recently as Friday, a large piece of the front of this building is falling off, and I didn't hear any. You tell me if I'm wrong, Mr. Cowan. I think, Joe, you said if there's damage on the outside, it might mean that there's further damage on the inside. When was the last time, Joe, I did want to ask you that you've been in this building, and did you notice any difference from what the last couple of times you've been in? What's the time frame been? What's the state you've seen the building, and has there been any change?
The last time I was in the building was, I believe, in November of 2013. Actually, it might have been a little more recent than that, although it was let's just stick with November of 2013 when I went into the entire building. And the collapse that we all are familiar with, the collapse that is 50% on Conley's property and 50% on the unowned portion of the property, that has expanded. The bearing wall in the center in between, a 16-inch thick brick wall now has a bow in it that's about 16 inches deep, which is substantial, which indicates substantial pressure on that wall. If and when that wall collapses, a 16-inch brick wall, it's going to come down and it's going to cause further damage. And then in the rear portion of the building, the Conleys, the most westerly end of the building, the high steel roof structure with the holes in the roof, the holes have expanded, I would say, by a good 20 to 30%. So again, it's indicative of what happens to a building when its roof membrane and its siding leak like a sieve. It's exposed to rain and steel. I mean, I likened it to the, the cars of the 70s and 80s that all rotted out because of, exposure to, if you can picture how those cars rotted out, that's what's happening to this building. And even if Mr. Cowan is 100% right from his observations of a year ago in May, the building continues to deteriorate, and the fact that the trim fell off in January of 2013, and this new piece that's about to fall off, and the sign panels that fell off, these things weren't happening when the building was maintained. They're happening now. They're going to continue to happen, and it's only a matter of time before there's a tragedy.
And Joe, where is the wall with the bow in it? Which direction is the
It's on the
bow
property
facing?
line of our building.
Interior wall, right?
It's an interior wall.
It's being damaged by another building, not our building.
Not according to the survey, it's right in the
It's
middle.
unrelated to his contention that there's another thing going on in that building, which I disagree with.
But
Is
the
the- is the-
condition has worsened. to
Is the
answer
wall
your question.
close to the trolley tracks, or is it far away from the trolley tracks?
It's
Where?
perpendicular to the trolley tracks, so if and when that wall collapses, it's impossible to say what will happen. Maybe nothing will happen. Maybe Fred will be 100% right. Maybe he'll be wrong, though, and maybe the collapse will cause the wall against the trolley tracks to extend outward. It's a roll of the dice.
Again, it highlights this issue of if you continue on the path we're going for, you're not going to eliminate the liability that the town has as the causative force of this bowed wall. Whereas if we work this thing out and get the building taken down, there isn't going to be any liability claim that exists anymore along the lines of, hey, your building with the hole in the roof has caused my building's wall to bow. I mean, it's another good reason to talk rather than taking immediate action. A week continuance is not much, and we'll come back in a week, and if we've made no progress, so be it. But I think we create a situation that gives us an opportunity to talk a little more.
Tom, was it your proposal to have a continuance until Monday? Is that what you were suggesting? We have a meeting scheduled for the 28th, which is Monday at 4:30.
Yeah, I would say yes.
If I may, if the board should decide to continue the hearing, can we be clear on what we're asking of the Conleys to agree to? That Mr. McDonough can go back to them, so that there's no...
Well, I think we should sit down and we'll discuss in a meeting, the particulars
We've
of
already laid out the particulars.
some of them.
There should
Right,
be an answer now.
Well, I can't speak for them. I'm not authorized to speak for them at this precise moment. But I am saying that I'd like my clients to sit down with the town in the next week. And, we'll thrash out any and all issues. And there can't be a downside to that. And you'll never convince me that there is a downside to that.
I would also, if we do agree to this, that I would remind you that Monday will come very quickly.
Oh, yeah, for sure.
So, we need some kind of real assurance, because we've been down this path way too many times before, that you get a couple of yeses and then stall, and all of a sudden the whole thing falls apart. We're not going that route again. We've had it with that route.
I wasn't part of any of that, so I can't speak to whether your perception's accurate or not. But it's your perception, and that's fine. All I can say is that I'm trying to set up a mechanism by which we meet and see if we can work out a resolution. That's all I'm promising, that we'll sit down with you and talk and try to find something that works.
It's in, well, at least personally, my best interest to see that building come down as soon as possible. And if this is a mechanism to make it come down sooner rather than later, then I am personally for it. Because the bigger picture, you talk about liability, the real liability is if should that one of those walls fall on those railroad tracks, while the trolley's going under it, we've all got much bigger problems than either one of us suing one another.
Right.
Well, meeting again certainly increases the possibility of a resolution more than not having a meeting. So let's have a meeting.
I would be willing to go down 2 tracks to continue this hearing under 139 until the 28th, and to allow the parties until Monday to have one or more meetings. I am concerned that the town administrator and the building inspector met with Mr. Connolly in September, and not only, it's not that they didn't come to an agreement, it's that there wasn't a response back when the town administrator and the building inspector said that they were expecting a response. So I think this has to be a cooperative effort. It has to be a genuine dialogue. It has to take into account what's happened in the past, and we need to move forward in good faith. And if we're able to get to a point where we have an agreement and where that makes everybody happy and that building comes down sooner rather than what 139 might allow, a proceeding under 139, I'm willing to give that a chance, but for a very short time frame. And that would mean continuing this hearing until Monday night. And depending on where we're at Monday night, possibly issuing an order at that time under Chapter 139. We have a fiduciary obligation. We're elected members of the Board of Selectmen. We have a serious concern about public safety in that area. The trolley tracks makes that a very unique location. There are people who walk along those sidewalks. It's a busy area. It's a lot of cars, a lot of foot traffic. I am very concerned about the condition of that building and the lack of progress that's been made to date in the negotiations to get the building demolished. But I would agree with Tom that if we can spend a few days, have the appropriate people in the room, have some genuine dialogue where people are coming into this not as a stall tactic, but as to take part in a meaningful dialogue and to work towards a common goal of getting this building demolished, I would support continuing the hearing until April 28th.
Well, I'll respect your wishes, but I'm actually going to go the opposite way. I don't want it continued for me personally, because I've been on this road too many times over the summer where we've come to the finish line only to have it collapse again. And we have spoken many times about this, how a handshake doesn't really mean anything. And it's been like this 10 times over the last 2 years. And every time it makes this Board of Selectmen look weaker and weaker, while it extends the time for the Connollys to get their permits. So I'm taking a stance right now that I'm not going to vote to extend this. I would rather go ahead and make a motion and just move simultaneously with their 40B application. And if one comes in before the other, we have the option of stopping it right there. But we've been made look weak over and over again, and I'm not standing for that.
It's really not about who's being made to look weak. It's about trying to get the building down sooner from your perspective.
Well, no, we keep giving breaks, Brian, you see, and it keeps coming back to bite us. And
Yeah,
soon,
but-
we have to take a stance and say that enough is enough.
But as representatives of the town, it's your duty to keep coming back and working with. If it's in the best interest of the town to do so, and it is in the best.
It is in the best interest, but I think making this motion is in a better interest for the town, because it'll force the developers to do something, in my opinion.
That's where.
Something where we can start.
That's where we differ.
Exactly.
I don't think it gives you anything you don't already possess, and I think it sends a message of not wanting to cooperate, and I'll try to dissuade my clients that that's not the case if it comes out that way. And
It's not
try
the
to
case,
keep the
it's just-
discussion going, because keeping the discussion going is the best alternative.
As Katie said, we're representing the town of Milton here. And it's in our best interest to make sure that this deal keeps moving forward. I'd like to keep it moving forward simultaneously with this 40B application. In the event that falls apart, we still have this one, the 139, to force this building to come down. That's all I'm saying, because over and over again, history will tell you that these negotiations fall apart.
Then I will, can I make a motion, or did,
You
I'm
can
sorry,
make
I
a
didn't want to interrupt if one of you were starting to say something.
Okay.
Then I'll move that we continue the hearing under Chapter 139, Section 1, to Monday, April 28th at 4:30.
Second.
Motion made and seconded, all in favor?
Aye.
Against? No. Motion passes. Thank you.
Thank you for your time.
Thank you.
Thanks, Joe.
And if you could ask the client to get back to them immediately.
Yeah, why don't we set that up before you leave? Could we ask maybe Joe Prondak to, what do you think, Brandon? Would it be better for you to reach out to Mr. McDonough?
Yeah, however you guys
Get
want
something
to
up, we'll get the availability from the town administrator and the building inspector as to when they're available to meet this week, and we'll make every effort to make,
You
people
know,
have very busy schedules. Obviously, we're coming into town meeting, it's a busy time of the year, but
yeah, no, I appreciate that
But-
you guys are under the gun on a lot of things. But yeah, I mean, you know, somewhat in my own best interest, but my brother's at this point would be to keep the attorneys involved, because I think it helps to diffuse the situation a little bit in a way that could maybe help. That's my feeling. So,
Yeah.
I'm happy to, it'd probably be best for anybody to communicate to our side through me. And I'm happy to communicate with whomever you designate. Good. Does that work?
so should we designate you, Brandon?
Right, so
Sure.
communication
Okay.
between the two attorneys
All right.
Yeah.
is key.
Wonderful.
All right.
Thank you.
Thanks, Brian.
All right,
Thanks,
appreciate
Brian.
it.
Thank you.
Thanks, Brandon.
Thank you, no problem.
All right, number 7 on the agenda is the taxi license renewals, taxi rules and regulations. I'd like to bring up our police chief, Richard Wells, to go over our new regs and regulations for the taxi cabs operating in Milton. Hello, Chief.
Chief?
How's it going?
Evening, Chief.
Good evening.
How are you?
I applaud your patience and determination. I don't think people watching on TV sometimes can really grasp how much time and effort comes out of this office on their behalf.
Thank you for that. So what's going on with our taxi renewals? I see all the inspections have
So-
been done.
Thank you to Ms. Conlon. These have not been updated since 1987.
I just heard.
Since 1987. So Lieutenant Alba, which Hackney comes out of his license, comes out of his office, with some help from Deputy Chief King, we met with Boston, because ours are the closest, and most of our cabs, or many of our cabs that operate in Milton also operate companies in the city of Boston and in Quincy. And Boston actually directed us to Cambridge, that they felt that Cambridge had some of the more inclusive regulations, so Lieutenant Alba did that as well. So I'm going to call this a first draft, how's that? I did get some changes. There's a lot that we've included in here, especially things that have come to light, just public safety, law enforcement, societal-wise, since 1987, things like sex offender registries, the immense pressure that I think every police chief in the Commonwealth is dealing with is people pursuing licenses to carry, and we did not feel that we wanted cab drivers carrying licenses, so if they were issued a Hackney license by us, that we would not want them carrying a gun while they're driving. So we put those type of restrictions in there. As far as you're the licensing board, the Board of Selectmen, for taxi cabs. That comes from you. We believe that's $100 fee. And is it annually, or is it?
Yes.
It is, okay. The Hackney licenses come for us, and those are every 2 years, and that's $25. So one thing you might want to think of is, do you think $100 is enough? I think it's worth more than $100.
Do you have a sense of what Boston and other
Oh,
communities
it's-
are charging?
Well, they have medallions, and the medallions in Boston are worth, because
Okay.
they regulate how many there can be. So Mr. Hurley's correct. It may even be $100,000 today. He may be correct. And the city of Quincy has just expanded theirs just recently, and I'm not sure exactly what theirs worth, but I do think
And if you would allow, we'll research that aspect of it. I think $100, it's worth more than $100.
I think it wouldn't be a bad idea to take a survey. And
Yeah.
the surrounding towns.
Yeah.
$100 seems very
Was it $100 at the time of the 1987 regulations?
I don't know, see, that's a good point. I
Might have
don't, it
been.
may have been, it's very possible.
I think we should revisit that.
And I know since I'm in the 7 years, I have not addressed anything in this as far as increases. And I think more than 100 is, so I'm going to come back to you on that one.
Okay.
We did put in things about requiring them to, some of the things that have come to light, requiring them to have a photograph that represents who the person is driving the cab.
These are all taken out of Chapter 40, basically?
Yeah, most of it, yeah.
Okay.
And we put it, some of the language, like, when you refer to a fare is the legal term for us that creates the nexus between the taxi operator and the fare is the person who is utilizing, that's with the agreement. So if we had to enforce a crime, like if someone escaped without paying, runs off, that's fare evasion. So they're the fare. That's where the word fare comes from. But so you can see there's a lot in there. The application requirement, item C5, is everything to you. That all goes to, we will review it for you, but that all goes to you as the Board of Selectmen. There are drivers' right of appeals, this and that. I know that, Lieutenant, I'm going to send you a recent, there's one charge being taken as a result of this most recent, we found an unlawful weapon in one of the cabs during the inspection, so that, there are things like that. The restrictions of hours, all of that, those are all new. Conduct of drivers, clothing, how they should be dressed. Again, on page 7, firearms by operators, use of alcohol control, so that has constantly been something, that is one issue that does creep up for us, so we wanted to address that. Taxi cab parking while engaging in business, things like that, where they park, electronic communications devices, cell phones.
That was one thing, electronic. It says, all taxi drivers, while not engaged in a fare, shall not use any communication device, including cellular phones. What about their talking to dispatch?
I don't think all of ours have dispatches. I think some of us take theirs by phone.
Okay.
And if they do, I think that would be allowed. We don't try to.
Right, yeah, I would assume it would be, yeah.
That would be something that's, the other thing that's, I don't know if it's addressed in here, is, and I thought of this as on the 40B application for Central Ave, is that once you do get to a conclusion here and something does get built, and I believe I addressed this just as far as the parking spaces for what they propose there, is we are all seeing that just the changes that are in the Central Ave Business District now already are creating real pressure on parking. We're dealing now with the parking, with just the construction people working at the new Milton Hill, I call Milton Hill House 2, I might be wrong, but you know what I'm referring to, is they're coming with 15 to 20 vehicles a day right at this level, at this point. And that puts, thank God Steel and Rye is not open, because that would really be a dilemma for us. So we may want to look at, as Boston does, having designated spaces for our cabs on the Central Ave Business District. We may have to, because that's one of the busier pickups, because it's right there at the Central Ave Station. That's one of the busier pickup spots. East Milton used to have designated spots, and actually it was a cab stand in front of where Starbucks is now. And it was actually it was Milton Taxi, was right in by Jim's Barber Shop, I still call it Jim's Barber Shop, and there were like 4 or 5 cabs there. That was a designated taxi stand, so. But that's one thing that's not in this, but we will have to come back to that. Displays with certificates, all that's prohibiting smoking, transportation of handicapped people, that's an issue that we try to we don't get a lot of complaints on that. Transfer of taxi cab licenses, that comes to you. That's something that, I can't remember when last time we had one, but it could happen. The physical characteristics we put in there, window tinting, reflective film, all those types of things. Clean and safe, we do, and Lieutenant Alma just did it. And now what we did was we actually included, we hired a mechanic from the DPW on the day of we did the inspections at Central Maintenance, and had him go through them from a mechanic's point of view, put them up in a lift, take a look at them, all of that. So there is a lot there. I welcome anything else you want to add, if you want to wait a couple more, I don't think we're gonna. And I will look in, I think $100, more than $100 is definitely reasonable. And I wasn't sure whether, because it comes to you, not to us, I didn't know whether you did them annually or by, like, with a Hackney license is every 2 years. So that's kind of my update on it right now, but I'll take any other questions that you might have about it.
Chief, you have to be licensed by the town of Milton to operate in the town of Milton, is that correct?
A cab business, yes.
Can anybody come from outside in here? They can, of course, right?
Yes.
But can they pick somebody up if they're here?
No.
No.
And that's an enforcement thing that we do deal with. So the license that you issue in the town of Milton
Yeah.
for the cab operation is specific to the town of Milton. And it is illegal to go and take pickups in Boston or Quincy or anywhere else. You're not allowed to do that.
So if, you know, if a car breaks down and you're going to call Blue Hills Towing, right?
Correct.
Because-
Okay, yeah.
Because they bid on it.
That's our towing contract, right, because they're our tow contractees.
Right. Is there any such thing as bidding to operate in the town of Milton?
I've never heard of that. I'm not really sure. One of the things that we don't really know is unfortunately, the person I knew the best was Vinny, who unfortunately passed away, is we don't really know how many trips or calls that they even do in this town. We don't, because it's not something we monitor. So we don't know how busy they are, I don't have a clue.
But there's no limitation to, I mean,
Absolutely, right.
anybody can apply and pay their $100
And run a cab
and run a
business.
cab.
Very inexpensive, like.
Yeah.
Yeah.
Right.
To have that luxury.
But there's no bidding process because it's not like a medallion where you...
Right.
And I don't know if we have enough demand where maybe we could enter into a medallion. Maybe you want to do that. Quincy, to me, is going to be our biggest, because they've just expanded them, and there had to be a reason why they expanded their medallion.
Yeah.
I mean, Curry College is running a shuttle service every day now. 8 or 10 hours a day, just from Mattapan Station to Curry. It begins at 5:30 a.m. every day and goes until like 8 or 10 o'clock at night. There's 3 shifts. So there has to, we know the number of students, between Fontbonne and Milton, there has to, never mind,
yeah.
right, and never mind what the Valley for and just general residents in the community. There has to be a pretty good usage of cabs in this town.
I would think so, yeah.
So I'd like to explore that a little bit, because I think we might actually be surprised at what this is worth to the town. Just as the towing, going back to the towing contract analogy, just as we found out the towing contract.
Now, did we find out the process, once we have a final draft of this, then we have a public notice period?
Yes, we got that today.
We have to publish it one time in the local newspaper, yes.
The full regulations or
Yes.
summary?
No, that's the good, well, that's.
I'm waiting
you
for
think
John Flynn to get back to me.
John, and Deputy Chief King has the same.
Okay.
It's obviously
So we'll look
old,
into that.
and it's vague. So the question is, what part do you want to publish? So
We weren't sure if we had to do an executive summary in the newspaper and then say that the full taxi rules and regulations can be available in the selectman's office and in the police department.
So we'll look
So
into
we're
that.
waiting on that answer.
And we have no problem doing that. We have no problem. This is a public document. We have no problem publicize it, put it on the website, put it on our department webpage, put it on yours, whatever. But John just briefly wrote to me tonight, and John King, and his opinion was, this was definitely an old vague, because I never heard of it. Was unaware of it. But we will do that. So one ad, and we think it only has to be in the Milton papers, because we don't operate outside of the,
Right.
you're only operating here.
That's right, the local.
Okay.
So we have a few licenses that are up for renewal. Is there a deadline by which we have to renew them? Is there any reason to wait for the new regulations before we renew them? May 1st, okay.
So,
I saw the change, the small wording changes that you had, Katie. I'm fine with those, but
most of them, I think there's only one word that I was just, at one point you had, I think, passenger, and I left it as fare because of just the legal term of that person being the fare, but
Yeah, I haven't, if they've been
Right.
revised, they haven't come over yet, or,
and there were a couple
No,
of questions.
they haven't
as
come
to
over
No, we
No, I
didn't
think it
revise
was
them
a
yet.
few
I just
questions
went
that
through
we
it
had,
Already
yeah.
to the police or the,
Yeah.
but,
yeah.
yeah, they were relatively
I thought it
minor.
was a good draft. There were just a few things we might want to follow up on.
And so we're doing that now. So we can wait, you want to wait till next week? And then, I'd at least like to get you an answer on the money.
We could make these changes and put it back on Monday's agenda. if
Yeah, that'd
you
be good.
wanted.
That'd be, man, make the changes, find out about what other towns are doing, maybe we can,
Or maybe the May 1st agenda. I have a feeling the 28th could be
And then approve the
It
tax.
could be, it has the potential to be a long meeting. We were there for a comment letter, so there may be more.
But we need it approved by May 1st, don't we?
What happens if you don't approve by May 1st? Could we extend
Their
them 30
license
days? Could we
expires.
Could we
So we
extend
need
their
to do this
licenses?
on the
Can't we vote the licenses tonight, and then the regs are separate? Because the regs have to go through a public notice
Sure.
period anyway
That's what
before
we can do, yeah.
before they're final.
Sure.
Have they already paid the $100?
Once they're approved and they come to pick up their license, they'll pay. So you'll have to make it
It would be
effective.
perspective.
Okay.
I think we'd have to do that anyway.
So we can do that, we can approve the licenses and
Yeah,
then
they've
we'll
all
do
passed their
regs.
inspection. They're all can be approved, the ones that are before you.
All right.
Yeah, and if they're up May 1st, we don't want to have them unlicensed. And
You want to make that motion, Katie?
I'll move that we approve the renewal of the following taxi cab licenses for 2014. Milton Taxi, Inc., 188 Providence Highway, Hyde Park, 26 taxi cab licenses. Milton Cab Company, 10 Des Moines Road, Quincy, 25 taxi cab licenses. And Parkway Cab, Inc., 66 Alpheus Road, Roslindale, 1 cab.
Second.
Motion made and seconded. Any further comment? Is that 26 taxi cab licenses times 100?
Yes.
Okay. All in favor?
Aye.
Unanimous.
Thank you, and I'll get back to you, but we'll have that, I definitely think the money thing is, 100 licenses definitely worth more than that.
I think so.
Yeah, absolutely.
Every little bit helps, right, Mr. Hurley?
Never hurts.
Thank you very much.
All right,
thanks.
And thanks again for
Good
your
job.
patience. Keep up the work.
Thank you.
Okay, next on actually, number 8 is going to be deferred, Amory.
Yes, Mr. Chairman, we're going to defer that to the April 28th meeting.
Okay, let's move on to number 9, signage request. We have some motions.
I'll move to approve a request from Artspace Milton for a temporary signage at the following locations announcing a community event that will take place on Saturday, May 10th, 2014, on the grounds of the Wakefield Estate. Brook Road and Central Ave near Pierce Middle School, Squantum and Adams Street, Canton Avenue and Blue Hills Parkway, and Blue Hills Parkway and Brook Road.
Second.
Motion made and seconded. Any further comment? All in favor?
Aye.
Aye.
It's unanimous.
I'll move that we approve a request from the Milton Amateur Gardeners to display a banner on the town green from May 1st through May 10th, 2014, announcing its annual perennial flower sale that will take place on May 10th, 2014, at the gazebo.
Second.
Motion made and seconded. Any further comment? All in favor?
Aye.
Unanimous.
Yeah, I'll move to approve the request from the Parks and Recreation to display a banner on the town green from May 10th to June 16th, announcing the department's summer recreation programs.
Second.
Motion made and seconded. Any further comment? All in favor?
Aye.
Aye.
Unanimous.
I will move that we approve a request from Fitness Unlimited to rehang 2 temporary sale banners on the roof of 364 Granite Ave, announcing Fitness Unlimited's Spring 2014 promotion.
Second.
Motion made and seconded. Any comment?
I have one comment on this.
Sign.
Well, these are sale signs, so they kind of blow in the wind and they sit on the top of the building, and we approved these in the fall. Since that time, I heard from a couple of people last fall who didn't like the signs and thought they were not attractive or it was not appropriate
too.
for the area. And I have to say, I wasn't a big fan of these particular signs either. This would be, what, Amory, a 45-day sign?
Yes.
So it's a temporary sign. 2 is just 2. It's not, that was the only feedback I had on it, but I thought it was worth noting, and this may be something that, I'm willing to vote this one and to
Why don't
approve
we
this
take
one,
a
but
look
I
at
think we
Let's
should
talk to them in the
We'll
future.
Maybe
take a
consider
look
that.
at it when they're up, Katie, and then we can,
get some feedback, further feedback,
for the
or
next approval.
invite the public to give us any feedback they might have.
Exactly, yeah. Okay.
Okay, well, this one worked out well.
All in favor?
Aye.
Unanimous.
Do you have to
I will be
recuse yourself?
recused on this one.
Okay, I'll
Sign
move
request.
to approve from Beth Israel Deaconess Milton Hospital to display temporary signage from April 23rd to May 10th, 2014 at the following locations, announcing the annual fundraiser gala that will take place on May 10th, 2014. Canton Avenue and Blue Hill Parkway, Reedsdale Road and Brook Road, Adams Street, and West Squantum Street.
Motion made and seconded. All in favor?
Aye?
Unanimous. One abstention. Number 10, boards and committee appointments.
Excuse me, Mr. Chairman, there's one more light request for Starbucks that was on your front agenda, but it wasn't included in
Okay.
your notes. Bill Clark is here to speak to it.
Starbucks have a new sign.
Starbucks has, they want to change out their 2 logos. Their logo signs are one's in the front window, one's by the back door. Right now, it says Starbucks across the top, and you see the picture of the woman on the logo. The new logo takes out Starbucks just has a larger image of their,
Woman.
okay, thank you. And the letters across the front on the sign band of the building will say Starbucks. There are 5 small bullet lights that come out from the top of that band, come back on the letters. Sign Review Committee looked at the size of the letters, the type of the letters, the lighting, and they had no issues except they cannot approve the lighting. They approved the letters, they approved the location.
Who approves the lighting, Bill?
Sign Review Committee agreed with the lighting. You have to approve the lighting.
You have any picture?
Yes, you do, in your packet.
It's in here?
Bill, I did have one question, and it's more general in nature with respect to signs. So my original understanding is the sign review committee was totally advisory, but
Yes.
I'm kind of hearing that there's certain things that they can approve, and where does that line of demarcation? I mean, like you said, they
Don't
looked
do
at-
lit signs.
Okay, but they can approve a non-lit sign?
A non-lit sign they can take in, you don't have to approve them. The building commissioner would approve them.
Okay,
It's either you or the building commissioner.
okay, but in any event, the sign review committee can't really approve anything, it's
No, they're
one or the other.
completely advisory.
That's what I thought, okay. Did we find that?
But they are recommending that
Right
this
after the-
proposal
right
be
after the
approved.
deaconess
Yes.
sign.
Is there after one?
Your deaconess request, hospital.
I have a paper copy of the memo if you,
Yeah, I suppose there's a picture here?
There is, yeah.
there is. Yeah.
There's 4 of them, right?
Keep going down, Tom, after planning office.
Okay, so it's that Starbucks coffee sign that we see right over the, okay. And the lights are going to be facing, it's going to be lit from the bottom up, is that what it is?
No, there's a small ledge on top of the sign band.
Yep,
These are on posts that rest on top of that ledge. They go out and they shoot back at the lettering.
okay, so from underneath and up.
It's a couple screens down. It's this one here. This is like
Okay.
what's on the Kennedy Carpet Building on the front side, the
Yes.
the
Okay,
gooseneck
so they would basically
lamps.
be over the sign and shooting back
Yes.
into it?
So they're almost like goosenecks.
Yeah. Okay.
Yes, instead of goosenecks, they're much smaller. These are small cans. They're the size of a Red Bull can.
Okay.
Okay.
So the motion was made and seconded, I believe.
Was it? Yeah, I didn't think so.
I think we had the motion made and seconded. We're in comment period, right?
No, we don't have a draft motion, that's the thing, it missed it on this, so.
That's-
Your motion didn't include
We have a motion?
Starbucks.
Yeah, I hear it. I make a motion to approve a request from Starbucks, 522 Adams Street, for new lettering on the building's front sign band and replace the 2 existing logo signs with a newer version of similar size and lighting as approved by the sign review committee.
Second.
Motion was made and seconded. Any comment? All in favor?
Aye.
Unanimous. Okay. Number 10, boards and committee appointments. We have a motion?
I'll move that we approve the appointment
Thanks,
of,
Bill.
the appointment of Diane DiTullio Agostino, 147 Ridgewood Road, to the Commission on Disability to serve through July 2015.
Second.
Motion was made and seconded. All in favor?
Aye.
Unanimous. Number 11, one-day liquor licenses.
Okay, I will move to approve a
From
request
Milton Academy,
from Milton Academy for a one-day liquor license for the following dates and locations. June 13, 2014, Cox Library, 6 to 7:30 p.m. Schwartz Student Center, 6:30 to 10 p.m. I'm going to butcher this. Pritzker Science Center, 6 to 7:30 p.m. On June 14, 2014, Wigglesworth Hall, 6 to 9:30 p.m. Admissions Office, Lobby Warren Hall, 6 to 9:30 p.m. Strauss Library, 6 to 9:30 p.m. Cox Library, 6 to 9:30 p.m. Elliott Commons Millet House, 6 to 9:30 p.m., Pritzker Science Center, 6 to 9:30 p.m., Schwartz Student Center, 6 to 9:30 p.m., and Robert Saltonstall Gymnasium, 6:30 to 9:30 p.m.
Second.
Motion made and seconded. All in favor?
Aye.
Aye.
Unanimous. Number 12, drain line cleaning and television inspection contract.
I'll move that we approve a contract in the amount of $42,884 to Height Camp, Inc. of Watertown, Connecticut, for the drain line cleaning and television inspection contract for work on Canton Avenue and Central Avenue, and to authorize the town administrator to sign all pertinent paperwork on behalf of the board.
Second.
The motion was made and seconded. Any comment? All in favor?
Aye.
Unanimous. Number 13, engineering intern seasonal appointments.
To approve the appointments of Brian Marsh and Edward Milazzo of Worcester Polytechnic Institute as temporary seasonal interns in the engineering department, contingent upon the approval by the personnel board.
Second.
Motion made and seconded. Any comment? These guys do a lot of work for Joe during the summer.
They had good qualifications, too.
Great qualifications. All in favor?
Aye.
Unanimous. Number 14 is the Hendry's 40B proposal comment letter. And I'd like to invite up Bill Clark and John Flynn, our town council. Bill?
Hello.
Bill Clark is our planning director. And is John coming? Okay. Should we go into executive session?
Yes, that's what we're scheduled to do.
Okay, all right. Hi, John.
John?
So, Bill, how are you? You did a great job on the Randolph Avenue comment letter. How's this one coming in?
We came up with a draft that we sent out to you last week. Haven't heard comments back yet, pro or con. I was hoping we'd get some direction.
Well, the Easter holiday and the
You got to bail us out here, Bill.
holidays
I
intervened.
do understand that you would like us to go back and work on those bullets and turn them into numbers. But before I tackled the formatting, I really wanted to see if there's something in the meat that you didn't like, want stronger.
I've got some handwritten pages. I haven't had a chance to type them in just because of, over the weekend, just because of work and the holiday yesterday and a few other things. But the main points that I have is that we need to, I think, expand upon, I guess it's starting on page 2 where we talk about the history of the project. And I have some notes. I'm trying to start working on that, but I probably won't be able to get them to you for at least a few days. But the history of fact that the proponent has been very involved in the process to do the PUD zoning. We touch on it. We start to mention the efforts that the town has made in conjunction with the developers of the 3 properties that the PUD was designed for in 2006, and the fact that the developers are very much involved in the process. And I think we need to bring that out and flesh that out a little bit more. And Bill, I didn't get a chance to email you, but we referenced the 2 ULI studies that recommend that this be a mixed-use development, so I'd like to see if we can, if you could send us copies of those, maybe we should either attach them or quote from them or somehow attach them as exhibits, but that's one thought that I had.
The proposed project is 57 units, correct? All residential?
Yes. 57 units, 49 2-bedrooms, 8 3-bedrooms.
The feedback from the community seems to be that they want some commercial in the building on the first floor. And I agree with that.
I think we said that in here. Want us to make that a little more punch.
Let me ask a question, though. I guess it's a 40B application, but that's all residentially zoned at this point?
You can have commercial in a 40B.
I know you can have commercial in a 40B. I guess my question is, can that override, in other words, can you put commercial in a 40B in a residential zone, or would it have to be rezoned?
Commercial is zoned.
But where they're proposing their building is mostly residential, isn't it? Or is it all residential?
The predominance of the building is in the commercial district.
Okay, I guess it was mistaken. I thought it was mostly in the,
No, it's mostly in the commercial
what
district,
portion of it's residential?
just the back parking lot.
Okay.
Well, there's a back loading dock in there, that loading dock area, and the parking lot next to it.
Okay.
It's been commercially zoned for a long period of time, that's why
Yes.
it's there, it was the ice cream factory, but the
Well, but
idea with
there
the
is non-conforming use, wasn't it?
No, it's commercial.
industrial,
They bought 2 houses back in like the 40s, early 40s. They tore down the 2 houses, and they built the receiving area onto it, and they left the parking lot beside it as the buffer. It was a parking lot.
Okay.
but that's really what I think we need to bring out in history, is that the fact that the plan unit development bylaw, a lot of effort was made by a lot of people in town, not only town officials,
It
but
was very proactive in bringing
But,
it to fruition.
yeah, the Conleys were, and the other developers, including one who's already built a development that's in compliance and got approval and a special permit under the PUD. So I think we need to just bring out the history of all, as Peter Jackson said at our public hearing.
We did say that here. These
Yeah.
efforts have been tremendously successful, resulting in major investment in our commercial districts, including a new mixed-unit development at Milton Landing and at 36 Central Ave.
Yep.
Adaptive reuse of 2 historic mill buildings on the Neponset River, which is beside Extra Space Storage. Approval of a mixed-use development at 2 Adams Street, which is in front of Extra Space Storage. Adaptive reuse of a large storage warehouse in Milton Village, which is Extra Space Storage. And approval of a new market-rate apartment building on Milton Hill House property. And the revitalization of a former car dealership for offices and a highly successful new restaurant. So we did hit on what there's a lot going on in that area.
Yeah, and that's why I think we just want to flesh out more and just give a little more history as to how all this happened, who was involved. The ULI is a respected organization, so I think we want, they've
There's
made a
2
recommendation
studies.
as to what
Put
they
them
think.
as exhibits.
Yeah,
Yep,
but if you can also send them, email them, do you have them on email electronically?
yes,
Okay, if you can email them to,
okay.
well, all of, I'd at least like to see them,
I would too.
maybe the whole
If I
board.
don't, I'll find them. I'll
Okay.
put them on electronic.
Because I think that goes to the point in the first sentence and then in the conclusion where the first sentence is currently drafted. It says, although the Board of Selectmen views the site of the proposed project as generally appropriate for an affordable housing development, the conceptual design, and we go on and we cite the reasons the design is not appropriate because of the size and the massing and all the different factors, but I think the board's view and prior board's views and the whole community's view has really been that a mixed-use development is what the town really would like to see there. So do we say it's appropriate for affordable housing or an affordable housing component because the PUD had an affordable housing, a 10% requirement? I think we still want to express our preference that, like the ULI, we still would prefer to see mixed-use development down there. I think we
That's
should.
the very last sentence. Based upon all the impacts discussed herein, the town respectively requests that Mass Housing Partnership direct the developer to modify its design to be compatible with the current vibrant Central Ave Business District's mixed-use makeup and the residential area at its borders on the west. If properly designed, the development would promote a truly valued transit-oriented development.
Yeah, but I think we want to bring that into the beginning, and I think we want to just make that a little more prominent, that certainly it's an area where there's vehicular, access to transit, mass transit, and it would be a good area for some affordable housing units, but the town's preference and what the town and the developer together have been working toward for a long period of time was that we think the highest and best use of the land, of the property, is to have a mixed-use development. And I think we should still bring that
Saying
out.
bring that up into the introduction.
Yes, and into the history section as well. But we have a week or so, we're just about a week. It's due on the 30th?
Your final draft will be on Monday's.
Monday.
Okay.
For approval.
So Bill, can you get us this final draft by the weekend or no? Sorry, to put you on the spot.
Well, I mean, I've got a few handwritten pages that I'll get them typed in and send them to you, and then we can go back and forth on them. And
We're going to approve.
I think the town
Monday. We should see it
administrator,
Monday.
okay, I think the town administrator also told me today that she has some comments also. So I think it can be a collaborative effort over the next few days to try to finish the letter up. I think it's a good draft, and the public safety and other comments are all appropriate, but my main point was bringing out more of the history and just fleshing this out a little bit more.
Why don't you send your handwritten notes, and we'll get them typed up in the office here, and then send them back to you to look at.
Okay.
Okay?
Mr. Chairman, as the basic thrust, you recall that in the prior two we've done, there was a big difference, namely, those proposals didn't meet any of the goals of development.
Smart growth, yeah.
Yes, because of where they were located. This one is near public transportation, it's near restaurants and cleaners and all that.
Perfect.
So with the addition of the emphasis on the mixed use, is the basic approach acceptable to the board? Because we didn't feel in good faith we can make the same objections for this site because of where it is. But yes, a lot of objections to what's proposed on the site.
I think you hit the major, in terms of objections, would be traffic and parking, clearly, but,
I
and
hit those
massing.
here.
And you did, yeah.
And I did hit the massing. I think the issues became one of, it's not that we're saying no to the development, it's we're giving them a roadmap to a better project. And that was my goal in laying out the outline, was to try to create a roadmap to make it a better project, to show where it needed to bend.
I'm good if we get the final draft by the weekend.
Yeah.
And then we can approve it Monday night.
Sounds good.
Thanks, Bill. Sorry, but give you more work. You'll have help soon. Thanks, John.
You're welcome.
You sticking around for? Where are we?
Town administrator's report.
Town administrators report.
Yeah. In the interest of time, I will defer my town administrator's report this
And I'll
evening.
defer my chairman's
You have a
report till Monday, which will probably, be my last time
Yeah.
as the chairman.
Yeah. Well,
Okay. All right, at this time, I'll make a motion to enter executive session to discuss the purchase, exchange, lease, or value of real property, 211 Center Street, and Assessor's Map, Section 1, Block 38D, Lot 9, Parcel, and to discuss collective bargaining strategy, Southeastern Public Employees Association, believing that having these discussions in open session will compromise the bargaining position of the body, and to return to open session to adjourn.
second.
Ms. Conlon?
Yes.
Mr. Hurley?
Yes.
Mr. Cohen? Yes. We're in executive session.